The broadcast is now starting. All attendees are in listen-only mode.
Hey folks, hello. Welcome to today's presentation where we'll be discussing everybody's favorite incoming regulation, the GDPR, or the General Data Protection Regulation, which of course is Europe's incoming law to harmonize data protection across the continent. And GDPR is, I'm sure, something that you've been hearing a lot about as we approach the May 25th deadline date, which is about 2 months away now. But much of the literature or resources that you're probably finding online and everywhere else isn't really geared for a private funds audience. And so what we want to do here today is talk about how to interpret GDPR's provisions and all of the new requirements from the perspective of a private fund manager. And to do that, Navitar has recruited two of the industry's leading thinkers on GDPR, that is Clifford Chance partner Daniel Silver and Corgentum Consulting managing partner Jason Scharfman. I'll introduce you to both of them in just a bit. But before that, allow me to introduce myself and perform a little housekeeping. I'm Nick Donato. I'm an industry strategist here at Navatar, which is a cloud software provider for the private funds industry, and that includes platforms to run your business if you're in private equity, venture capital, hedge funds, real estate, mezz, and more. Should you have any questions during today's presentation, by all means, send them our way. You should have a GoToWebinar tool that should be in front of your screen there. What I've done is I've just reserved time at the end to field them. And as a FYI, because this comes up a lot, we'll make sure to send out a recording of today's broadcast. So just look for that in your inbox in the coming days. So let me give you the quick background on Navitar and how we're connected to your industry. Navitar is by far considered the premier platform to do things like run your fundraisers, manage your LP relationships, and source and manage deals. Now, in the old days, you, of course, had to do that off of a clunky Excel sheet or maybe a Word document. But Navitar it's what we are. It's a smart platform that allows your partners and your associates to collaborate together. And we offer proprietary workflows to make sure that you never do things like leave an important LP ignored for too long or miss out on a deal that maybe matches your investment criteria. We have over 600 customers across 35 countries and growing. We are built on top of Salesforce and Box. And what that means is that we've taken the two most trusted names in cloud security and really just configured them for the private funds model, meaning that just everything comes ready outside of the box. So that being said, I'm going to ask our two distinguished speakers to introduce themselves and give the background on them and their firms. So Dan, let's start with you, and then we'll move on to Jason.
Sure. Thanks very much, Nick. My name is Dan Silver. I'm a partner with Clifford Chance based in the New York office. Clifford Chance, the global law firm with offices throughout Europe, Asia, and here in the U.S. I am a partner in the litigation and dispute resolution group and focus on data security and cybersecurity. I serve as co-chair of the cybersecurity and data privacy group here in the Chance and counsel clients on a wide range of cybersecurity related issues, everything from data breaches to regulatory compliance to follow-on private litigation.
Thanks, Dan. And Jason?
Yeah, hi, everybody. My name is Jason Scharfman. I'm the managing partner of Corgentum Consulting in the New York office. And we are a consulting firm that specializes in operational due diligence reviews on behalf of LPs in private funds as well as long only as well. The focus of our practice is reviewing a lot of technology, compliance, and cybersecurity risks for LPs considering investing into a fund, and then post-investment ongoing monitoring. So certainly GDPR falls within that bandwidth, and we've seen a lot of good questions from LPs on this, as well as fund managers that we review. Happy to talk about it today.
Thanks to both. And so the way I want to start this conversation is by first saying that if you're a private fund manager out there and you're feeling worried about your firm's progress on GDPR, you should at least maybe take some comfort in knowing that you're not alone. From what I've been seeing and hearing and reading is that much of the private funds industry is still in a little bit of a wait and see mode to see how GDPR compliance will shake out. And even though that May 25th deadline date is looming, I would encourage you all to see this as a marathon that requires, let's say, some careful pacing. Nonetheless, it's important to get a handle on your GDPR compliance planning. And as I alluded to earlier, that can be tough knowing that much of the literature out there isn't really geared for our industry. So, for example, you may be feeling confused about how to delete data at LP's request when a securities regulator is telling you otherwise. Or, for example, what types of insurances you should receive from your third-party vendors. And on that point, I'm going to ask Navitar COO Ketan Kankar to speak to us a little bit later on how Navitar is tackling that. So with all that being said, we'll do our best to angle this conversation from the perspective of what a GP should care about. And so, Dan, let's start with you. And to kick things off, let's discuss who in our industry is even impacted by the GDPR.
Sure. And let me say, Nick, I agree with you in terms of what I've heard from clients and audiences I've spoken to. I think that particularly US-based private fund managers are sort of still trying to wrap their heads around how this regulation will apply to them. So I guess just to start at the beginning by defining a couple key terms that will come up throughout the course of this presentation. The GDPR really categorizes all entities in terms of two different categories: data processors and data controllers. And most fund managers, the ones who are impacted by GDPR, will be characterized as data controllers. And a data controller for these purposes is really just any entity that collects data, personal data, and uses it for any commercial purpose. And personal data is defined very, very broadly. So it's really any information that could be used to identify a human being, even a name, a date of birth, an address. It's a broader sort of set of identifiers than would typically be considered PII or personal identifying information under existing US law. So that's what a data controller is. And as I said, most fund managers will fall into that category. We'll talk a little bit more about how you'll be captured by GDPR in a moment. The other important category is a data processor, and those are entities that do something with personal data in connection with providing a service to a data controller. So the best example of that would be for your fund administrators who are doing AML and KYC types of reviews. Those would clearly be data processors for these purposes. And each categories have certain obligations under GDPR. So I guess having said that, turning quickly to how and when does GDPR apply, particularly to a fund manager that's based in the US or outside the EU, it can apply in one of a few different ways. So first of all, if you have a quote unquote establishment in the EU, and that could be, obviously an EU registered fund, a fund manager would of course count as an establishment, or even a representative office of a US based manager would count as an establishment. So if you have a kind of brick and mortar presence in the EU, then you are very likely going to be covered by GDPR. If you don't have a brick and mortar presence in the EU, then you still may be covered under one of two different categories. The first is if you are, quote, offering goods or services into the EU. And so that has to be some sort of kind of intentional, systematic marketing to EU-based investors, could be individual investors or institutional investors, that is going to render you subject to the GDPR. And that's, I think, probably the most important category in the sense there's a lot of US-based fund managers who don't have that brick and mortar presence, but will be captured by that offering goods or services prong. And then lastly, and this is probably a little bit less applicable to most of you listening today, if you're monitoring the behavior of EU residents, then that can also render you subject to GDPR, even if you don't fall within one of the other two categories. And monitoring behavior could arise, for example, in the context of alternative data harvesting. So if you're doing something with alternative data and that data includes personal information of each, that could at least potentially qualify as monitoring for purposes of GDPR. So those are sort of the broad categories in terms of who is impacted.
And then Jason, can you speak to that same point we alluded to earlier about just how the different asset classes, how ready they're feeling about GDPR?
Yeah, I agree with both your comments. Definitely been, anytime you have a new regulation such as this, and particularly with GDPR, because it sort of bridges the gap between technology and legal. The feedback that we get from all the managers we talk to is that I wouldn't say they're behind the curve, but exactly as you said, sort of a wait and see approach. Nobody wants to be sort of the first one sticking their neck out there, declaring this is how we're going to do it. So it's kind of a cautious and slow approach in terms of implementing the solution. I would say certainly people who are have direct offices in the EU, so like a hedge fund, for example, who is based in New York but has a research or marketing office in the UK, for example, is definitely, I think, ahead of the curve based on what we've seen in the market, as opposed to a entirely US-based private equity firm that just raises capital in the EU, that type of thing. So certainly I would say a physical presence is one of the things that drives how far along different managers are in the process. The next thing I would say also is just in terms of how well resourced managers are. So if you look at, once again, at hedge funds, we've seen obviously the larger, better resourced funds taking a more proactive approach in these types of areas because they have the resources to, whereas smaller funds, even though they might be raising more capital in Europe than, let's say, a larger fund, on a percentage basis, they're a little bit more behind the curve. But in general, if I had to sort of rank it, I would say hedge funds are sort of leading the pack with compliance, seconded by private equity, and then everyone else. So that's sort of the general approach that we're seeing.
And then, Jason, a quick follow-up question to that. I know that hedge fund managers, private equity managers, the entire industry, they're all working with lawyers. They're all trying to determine just how impacted by GDPR they are. Whatever conclusion they reach, is there a best practice in terms of how they share that with LPs? I know that you work with LPs. Are they asking about this? Is it a simple declaration that, yes, we're on top of it, or is it something else?
Yeah, I would say it's a little bit of a balancing act, right? Because the general perception among a lot of managers is they don't want to raise certain types of issues with LPs that they don't have to, simply because they don't want to make them nervous, right? In terms of another thing that they have to comply with or another potential risk area that could expose the manager to, regulatory action. So I wouldn't say that they're proactively, waving the flag. If investors are asking about it, some managers, I would say, are better coordinated in their response than others, right? So some have started amending their existing policies, compliance policies, or technology policies to talk about how they're going to approach this. Others have just put together, one or two paragraphs saying, yes, we know what GDPR is, and we have a plan to comply with it. Sort of a, off-the-shelf response, and that's useful both to get the manager themselves within their firm to sort of coordinate their thinking in terms of how they're going to approach this, and then they can share that with their employees. And obviously the added benefit is they have something for investors when they ask about it. But, we've also come across managers who just sort of say, wait and see. Yeah, I might be affected. I'll talk to my lawyers if the issue comes up. And that's certainly at this point in the game, not acceptable for LPs. And it just gives them another sort of reason to say, okay, scratch my head. What else? Is this manager really taking this seriously enough? So,
yeah, good points. And so, Dan, earlier you mentioned about if you have a brick and mortar establishment anywhere in Europe, you're going to be impacted by GDPR, but that there's still certain things that could hook in a non-European manager, and that's with respect to marketing. So I want to move on to that and hear your thoughts.
Sure. So, I mean, and that's kind of, I think, a lot of the questions that I've gotten over the past couple months have been focused on exactly that issue. You know, what kinds of fundraising or marketing activities will make me subject to GDPR if I don't have any sort of physical presence in the EU. And I think, you know, it's obviously going to be a context-specific kind of analysis for any particular manager. And I think, you know, what generally speaking, what we've been telling clients is, you know, look, if you happen to have a handful of EU investors who have, you know, come to the fund in various ways, but not through any sort of organized marketing efforts, then you're probably going to be okay. And so one, you know, specific question we've gotten is, you know, if we've relied on the reverse solicitation exemption to, you know, sign up EU-based LPs previously, you know, is that going to sort of also make us exempt from GDPR? And so I guess, you know, the answer is not necessarily, but maybe is probably the best answer we can give. You know, there's no, you know, reverse solicitation is not a defined term within the GDPR. So there's no sort of specific reference to that particular concept. What there is sort of, as I noted earlier, just the general concept that if you are intentionally offering goods or services into the EU, then you're subject to GDPR. And so I think that, you know, again, it's going to take sort of an analysis of what kinds of marketing activity are happening. Are there, you know, regular in-person meetings occurring in the EU? Are there, you know, EU-based intermediaries that are being used to raise capital? You know, what sort of percentage of LPs are in the EU? Is it a significant proportion? So all those kinds of questions will be relevant to this analysis of, are you offering goods or services into the EU? I guess one other thing I would mention is that I've also had a lot of questions about retroactivity. And so, you know, questions like, well, if we used to do, you know, organized marketing into the EU in previous years, but we've stopped it, we're not doing it currently, and we don't intend to do it after May 25th, which is when the GDPR becomes applicable, then how does that, you know, apply? And thankfully, the GDPR is not retroactive in the sense that it won't look back to capture past activity. So it's really, the analysis should really be made on a going forward basis in terms of, you know, what's the state of play going to be on May 25th and in the coming months and years. One caveat that I would note in that regard, though, is that if you perform that analysis and you conclude, okay, I am going to be subject to GDPR going forward, you know, whether it's through a physical establishment or offering goods or services, then the GDPR is retroactive in the sense that you've got to look at all your existing agreements and policies to make sure that you are GDPR compliant, even with respect to investors who existed before May 25th. So it's not just, you know, something you have to worry about when you deal with, you know, new investors. It's something that will apply to any EU data that you hold after that date.
And then, Jason, at the micro level, we have a lot of fund managers concerned about what changes they need to make to their website or what changes they need to make to their email behavior, let's call it. Insights on that?
Yeah, I think the first thing that they have to do is, and this goes to just having a fundamental understanding of the requirements of the law, and that's where working with their attorneys can give them that sort of outline to make sure that they understand what the requirements are. Then once that's in place, they can apply that to their entire business. So that would be certainly on the website if they're collecting investor data. or if they're, whether that be solicitations or requests for further information, but more likely that they're distributing investor data. And a lot of times that it will either funnel through a third-party provider, such as an administrator's website, or, there's a number of off-the-shelf vendors that can, or data rooms that they use to transfer this data. So it's I would say a collaborated effort, and I know we've sort of hinted at this throughout the call already, but a collaborated effort, not just, for example, saying the manager's own website, but the entire universe of ways that they're interacting with investors. And the other thing is, whether it be communications with investors or disclosures that they make in other ways, right, through email, or that they collect information through email, just being conscious and sort of training the employees of the firm to say, okay, there's this new regulation out there. It primarily affects how you collect and store and notify people about their personal data, right, on a high level. You should all be aware of it and be careful how you collect that data and what to do after you get it. And so then apply that across the mediums. That's what I would say.
Right, and that of course too is an ongoing compliance exercise. Moving on to the scary elements of the GDPR, I want to talk about what happens if you're in violation of the regulation. And so, Dan, that's an easy one there for you to kick us off with.
Sure, and this is what's obviously been attracting a lot of attention and headlines. So the GDPR includes fairly stiff potential penalties for non-compliance. And those penalties can include monetary fines of up to 4% of global revenue for the entity that violates the GDPR. There's been a lot of speculation in terms of how stringently this is going to be enforced, particularly with respect to non-EU based entities. And that's a difficult thing to predict. I mean, I know that in the UK, for example, the Office of the Information Commissioner has, historically been a relatively small agency. They've certainly committed to bulking up to have the ability and capability to enforce this new regulation. And just in the last few days, we've seen headlines from that agency, conducting search warrants in connection with, for example, the Facebook scandal. So they're certainly, at least outwardly, professing that they're going to do their best to enforce this regulation rigidly. And I think, my hunch is they'll probably start with some sort of low-hanging fruit examples of enforcement cases before moving on to, more granular kind of violations of the regulation. The other thing that I should just say in terms of breaches and potential penalties is that the GDPR includes a very tight 72-hour notification deadline for data breaches, when those data breaches have essentially a material risk of harm to individuals. And so an entity that's subject to GDPR, whether they're based in the EU or not, is supposed to notify a privacy regulator in the EU within 72 hours of discovering a breach, essentially without any exception. You do have a little bit longer to notify the affected individuals. That must be done without undue delay. But my sense is they'll be looking for, pretty rapid notifications to individuals as well. And so for those of you that have never, thankfully, had to deal with a data breach, a 72-hour time frame is a really, really tight time frame to have to make any notification. And it's tighter than most of the existing requirements that are currently applicable in the U.S. So, what we've been telling clients is the only way to really prepare for that is to make sure that you've done some practicing to have a sense of kind of who would have to be involved and what kinds of steps have to be taken to be able to make a notification within that kind of a tight deadline.
And Jason, knowing that every private fund manager will have their own internal practices and policies around data management, can you still speak to some of the best practices that they should be taking on in light of what Dan had mentioned about things like obtaining consent and notifying an LP about a breach?
Yeah. So if you look at the actual regulations, right, it's just further highlighting, the point that they're a little bit more strict than some of the other laws in terms of the 72-hour turnaround time frame with consent, right? My understanding is it has to be in plain language, right, and not full of complex legal terminology. That's sort of an emphasis, user-friendly emphasis in this law. So not only do you have to follow the laws of getting consent, right, the regulations of getting consent, but you have to do it in the proper way. And I think that what we see, the general thinking on that is twofold, right? Making sure people want to cover their bases. So making sure that their lawyers say, okay, this language is plain enough that you can use it to get consent, but also just having a conversation with people, and whether it's sending them a separate sort of one page or whatever it is, fund managers to their clients that say, look, this happens. These are your rights. This is what the law means. Almost like or two managers that have been very proactive in GDPR, sort of taking steps in that regard, putting together these sort of, one-pagers when these types of questions come up that are helpful. So that's the first thing I would say is understanding, that you can't just sort of throw a disclaimer at the bottom of an email or at the bottom of a marketing document that's highly technical and just assume by default that you're going to be covered. The other thing is, as part of this, as Dan mentioned, the 72-hour breach notification, but then there's also these expanded right to access data. So you have people, if I'm a fund manager and I have LPs that are invested in the fund, under GDPR, there's expanded rights in terms of telling people what the data is going to be utilized for and for what purpose. And once again, I think that facilitates sort of the plain language elements of it, and also in terms of the consent, understanding that there are portability, which we didn't really get into. There's portability concerns that the data can be portable, and then also erasure concerns. So my point is, I think a manager is doing themselves a disservice if they say, oh yeah, we're just going to get sort of informed consent and we've checked the box in this requirement. That's not. It's sort of a puzzle of many different things that touch consent. It's not just consent in and of itself.
Right.
Just to add to that quickly, Nick, and I agree with what Jason was saying. One thing to keep in mind about consent, it is, a bit tricky in terms of what qualifies as consent under GDPR. The reason, I guess to back up a little bit, the reason we're talking about consent is that, under GDPR, you have to have essentially a lawful basis for using the data that you're collecting in the way you're using it. And consent is one of those potential lawful bases to have. And as Jason was saying, consent under the GDPR is more onerous than it has been thought of previously, and it can't be kind of legalese, so to speak. One thing that we've been telling people is that it may be actually better and easier to rely on one of the other enumerated bases that exist other than consent to process data. So, for example, there's a separate prong that essentially is legitimate business purpose. And so, if you're, for example, collecting personal data from investors to meet your know your customer requirements under US AML law, that is likely going to be a legitimate business purpose for processing that data in that way. And you just need to be sure that you've documented the fact that you are using that data for that legitimate purpose, and that use is disclosed to the investors. So that's just sort of one example of a different way to sort of, fall within the GDPR's requirements in terms of having a lawful basis. You don't have to necessarily rely on consent for each and every use.
Yeah, and these are all complex questions that create an easy segue into my next question, because there's one person in particular at the firm who's going to have to be ultimately responsible for these, and that is the data protection officer. So Dan, let's stay with you in asking just what are the legal requirements of a DPO? What should they be aware of?
Sure. So I guess let me first say that not every data controller will necessarily have to have a DPO under GDPR. So you're required to have a DPO, a data protection officer, if you are, quote, engaging in the regular and systematic monitoring of data subjects on a large scale. So for private fund managers, that's really going to depend on your size, the scale of your activities with respect to the EU, things of that nature. So it's possible this requirement may not apply to you, even if you're otherwise subject to the GDPR for one of the reasons we talked about earlier. If you do have to have a DPO, and it may be useful to have a DPO or a DPO-like person, even if you don't fit in the definition of what I just said, then that DPO has to be, there's certain requirements under the GDPR as to what that particular person must do and must have the ability to do. So they must be independent, sort of similar to how we think of a CCO role. They must have independence. They must have adequate resources and qualifications to perform their duties. They must have the ability to have direct access to senior management to escalate issues when necessary. And they, of course, monitor compliance with the GDPR and cooperate with any requests for information that are submitted by data protection authorities. So those are the basic DPO requirements.
And Jason, we heard Dan logically refer to the CCO as a natural candidate. Is there any concerns in assigning the CCO?
Yeah, definitely. I think they're logical correlations. I was just going to add another thing that we've seen people sort of equate it to in practice is like a MLRO, which is a money laundering reporting officer, which is a requirement of some funds as well, which in some, many cases could be the CCO. So I think, Dan enumerated a number of really good similarities. One of the other things that we see that people, LPs and managers in the way that they think about it is that there's a requirement that the DPO must report to the highest level of management, avoid conflicts of interest, have appropriate resources. So I wouldn't say that there's anything wrong with having the CCO be designated as the DPO, but as with most of these things, there's sort of the titular concern, right? Who's having the title, and then the sub concern of who's doing the work, right? So in many cases, you'll have a deputy, CCO or a deputy money laundering reporting officer. The point is, I think that depending on the size of the firm, also, in a big, large, complicated firm, the CCO might be more of a quarterback as opposed to doing the nuts and bolts of this type of work. So that's kind of the concern, or one of the concerns that we see is that this CCO is a busy person and not necessarily involved with all the minutia. So having the appropriate resources internally, whether that's a deputy person who's involved more in the day-to-day or subcommittees that the CCO then monitors, that can be focused on GDPR, whatever approach they decide to take. The concern is less who holds the title and more is there appropriate oversight of this with somebody who has enough time to really dedicate to managing this type of issue.
And they do have the option of delegating that to a third-party service provider if they wanted to. Is that correct, Jason?
I believe so, yeah. I believe that they can delegate it, but ultimately the responsibility still remains with the firm. So once again, just because they sort of delegate, it's sort of like an outsourced chief compliance officer, right? The firm is still responsible. The manager is still responsible, even though they've delegated the responsibility. It's not a risk assignment, I would say. It's more of just a additional resource, right. which there's nothing wrong with that type of framework, by the way. But certainly regulators have criticized firms that just try to completely outsource that responsibility because they can't. So.
And well, speaking of third-party vendors, Dan, if you could give us some basics on what GPs should be thinking about when working with third-party vendors from the GDPR context?
Sure. I mean, so as I mentioned before, you have data controllers, and most managers, if they are subject to GDPR, will be data controllers. And then you have your data processors, who are performing sort of service for the controller. And as a data controller, your obligation essentially is to ensure that your data processors are GDPR compliant. And so typically how that works is, there will be a term in the services agreement that mandates GDPR compliance. And one of the things that the data processor must commit to do is notify the data controller in the event of a data breach. Again, that notification must be very prompt, so that the data controller can then in turn fulfill its notification obligations to the government authorities and to any affected individuals. So essentially what we've been telling clients is that they have to think about, okay, of all the various vendors out there, which ones are going to be doing doing something with data that would include personal data of EU residents. And for each of those kinds of vendors, you have to sort of take a look at the services agreement, take a look at their policies with respect to this issue, and make sure that they have committed to be GDPR compliant. And so that typically is IT, any outsourcing of IT services, fund administrators, things of that nature, AML resources, to the extent those are being outsourced, would fall within that requirement as well.
And Jason, we heard Dan mention. Oh, sorry. Go ahead.
I was just going to add a follow-up to that about, on a related note, we've seen a lot of people being not puzzled, but really challenged by the use of the cloud into that equation. So if I am a manager and I store data on a cloud, and also if I have a vendor and they store data on a cloud, there's additional considerations there, right, in terms of the privacy, security, of the use of that cloud, and potentially who has access to that data on the cloud. Because if I'm a fund administrator, if I'm a hedge fund and I have an administrator and their administrator is storing data on some other cloud, and there's a breach of the cloud company, let's call it, right, then that can affect all the administrator and the fund. So I would that's an overarching consideration of all of this. Whether it be at the manager or a vendor, is those kinds of, because the cloud is so popular.
Right. And going back to Dan's earlier point on, you have your fund administrator, you may have an accountant, you may have an IT provider, which may be in the cloud, how you coordinate the compliance across those multiple third-party service providers.
Yeah, and what we've seen some funds, that have really sort of dug into some of these issues is they'll start talking to their administrator, let's say, and the administrator will then, they'll provide all this information about the cloud, but there's further questions that need to be researched in many cases. So that's why starting this process early, rather than waiting until a breach occurs, because of the particularly tight deadline and the large potential penalties, is certainly advisable, right? Because there's not going to be enough time to do this, and it'll be after the fact. So that's why, you really have to kick the tires on these issues earlier.
Final question, and this one, because we are 2 months away, what I'd like is for each of you to just provide some last-minute items that should be on any GP's checklist in the run-up to the May 25th deadline. Dan, if we can start with you.
Sure. I mean, basically what we've been doing when we're contacted by a fund manager or other client, at this stage is, I think the first step obviously is answering the question, am I going to be subject to GDPR? And that can require some thought. After that is yes. Then what we would recommend is kind of create a checklist. And, I use the word checklist, but it's really a bit more there's a bit more thought involved than that. It's sort of a tailored action item list that is tailored to the applicable manager, and sort of identifies the types of data that are being collected and the types of processors that are being used. And then, triaging essentially, okay, now that we know, where we think our obligations are going to lie, what are the most important things to make sure we have looked at and accomplished in advance of the May 25th deadline. And those types of things are going to be, among others, updating your disclosures, to LPs and any other EU-based individuals who you may deal with, and also, reviewing and updating your services agreements. Those are probably going to be the most important things. There'll be other things to think about as well, such as updating compliance manuals and staff training and things, incident response planning, things of that nature, which are also important. But we've been, typically kind of helping clients triage and dealing with some of those items that I mentioned first as the most pressing issues.
And Jason?
Yeah, I think a few things. First of all, we've seen some people say, or sort of attempt to buy time and saying, well, Brexit, like in the UK, Brexit is still sort of up in the air, and that might cause this to change, specifically within the UK. The UK government sort of said, no, this doesn't matter. Out there. The next thing I would say is really these types of considerations and personal data. What we've seen more sophisticated managers and particularly more sophisticated LPs focus in on when they're looking at these managers is saying, okay, you have these considerations for this type of data, but this is just one of many laws that you're complying with, right? Or will have to comply with. So do you have really an intelligent, coordinated plan to approach these types of requirements so that you're not duplicating the efforts across each law and restarting the wheel, right? So one of the elements of GDPR is sort of that systems have privacy by design. So that's just a function into, there's other laws that have other requirements in terms of the personal data, security, et cetera, that managers may be subject to, and just understanding really, are you doing this in a coordinated way? And look, nobody expects a manager to get it perfect the first time, but the better managers we've seen have said, okay, this is just part of a bigger process. We need to, understand how we're going to coordinate this across the firm, as opposed to let's just run as fast as we can to comply with GDPR, and then we're also doing that for 5 other laws or requirements. So just coordination. I think that's the big key.
Right. Thanks for that, Jason. So earlier you had mentioned cloud security. So what I want to do now is bring in our COO, Ketan Kankar, who is going to walk us through how Navitar, which is a cloud provider, has been approaching GDPR. And even if you're not a Navitar client, I would encourage you to watch, because as more fund managers migrate to the cloud, this is a good example of the types of assurances that you should be receiving from your provider. So with that being said, I'm going to turn things over to Ketan.
Yeah, thanks, Nick. And as all of you have already heard, there are several aspects to GDPR and overall the burden of kind of managing the data, the burden of making sure the data is secure, but also the importance of utilizing or using the data per kind of the guidelines. So from that perspective, and you'll see kind of a few of the items listed out here, and then Jason had also mentioned cloud security as another issue, because many of you may have systems that are cloud-based. They're getting more and more popular. And for all the customers of Navatar who are on the platform, who are on the webinar today, or kind of, as Nick said, anyone who's looking at a cloud solution, I think these are some important aspects to consider. From a Navitor platform perspective, we already have all these things in place to enable our customers to manage and kind of be compliant with GDPR. A big part of that is data security, and the ability kind of making sure that all the data that you have in whichever cloud provider that you're using, and in this case, kind of we're talking now about Navatar, that the data is secure, it's encrypted, it kind of, even if there is a data breach, there are security protocols that will not allow people to actually access the data. So it becomes even more important now when you're making a decision in terms of any system to choose from, to make sure that the security is super tight. And again, from a Navatar platform perspective, I think that's one aspect that we're really proud of. The second thing to be looking at will be, we talked about the fact that a lot of new policies have to be put in place. And that's great, but in terms of execution of those policies, you also need a lot of tools to not just kind of track the information, but also execute on some of the new policies and processes that you may want to put in place. And again, we've included a whole robust set of tools that allow you to, for example, track all the different types of consents, to be able to automate some of these policies, so that if, let's say, if you had to remove all the personal data for anyone, for an LP who requests you to do that, it doesn't become too tedious or too manual an exercise. So there are lots of tools that are available that allow you to track consent, to allow you to move data securely from kind of your system to somewhere else, to be able to kind of any requests that come in from LPs to remove any data that you're tracking. These tools allow you to do that seamlessly, and again, reduce the risk of manually or kind of losing things in the oversight. So those are both important aspects, the security of the system, as well as the tools that are needed to manage and comply with the policies and procedures that you're putting in. So those were, Nick, a couple of things that I thought we'll mention in terms of kind of Navatar's readiness, but also in general, if you're looking at any cloud provider, the kinds of things that you may want to ask that cloud provider about their ability to support the GDPR processes here.
Thank you, Kane. And so we are going to turn things over to audience questions, and we have a few that have come in. And the first one is touching upon something that, Jason, you mentioned earlier around Brexit. They're asking, as a London-based fund manager, how does my GDPR compliance considerations change in light of Brexit? If you can touch upon that again.
Yeah. So as I mentioned, that's a concern, or sort of, to talk more frankly, a smokescreen that some people are saying, well, we're not sure what's going to happen with Brexit. That might be overturned, or there might be some sort of compromise. And the EU government the UK government has said effectively that they agree with the EU's GDPR principles, and that they're going to comply with it. And that is consistent, I think, with the regulatory approach taken by the UK across a number of different areas in relation to the EU in the sort of post-Brexit vote approach. So I think certainly the most conservative approach is to assume that they're going to have the same requirements. And the other thing I would add is there's a number of other regulations that are more UK specific, such as there's one called PRIIPS, and that has a number of other data requirements that could affect managers as well. So really, the fact that a manager is based in the UK, I would argue that they potentially have even more requirements and a higher bar to meet for issues surrounding data security, privacy, consent, everything we talked about on this call, as opposed to a manager in Switzerland, for example, who might just be thinking about GDPR type considerations. So.
Yep. And second question that's come in, this one coming from a New York City based hedge fund, and that regularly leverages alternative data. Dan, that's something that I know that you had mentioned earlier. They're wondering how much of a new compliance risk this represents under GDPR.
Sure. So as I mentioned earlier, one of the ways that a non-EU based manager can be subject to GDPR is by through the monitoring of personal data of EU residents. And so, if the way that you're using alternative data, if that data includes personal information about EU residents, and again, personal information is defined very broadly, so just the name, an email address, really any kind of a personal identifier, and you're using that data in such a way that could be construed as monitoring, and unfortunately there's not a ton of existing guidance out there as to what monitoring means, then you very well may be subject to GDPR as a result of that use of alternative data. And once you're subject, you're subject. And so, some thought should be given to, how that data is being used and whether there's any way to, tweak the way in which the data is being used prior to May 25th. If that's the only basis upon which, an entity is going to be regulated by GDPR, it may be worth, changing the way that data is being used rather than engaging in an entire GDPR compliance undertaking.
Right. We have time for one last question, and this one is arguably a difficult one. Someone is saying how GDPR planning should sync with other incoming EU regulations like the EU e-privacy regulation, which we all understand has not yet been into effect. But how much should that play into current GDPR compliance planning?
Yeah, it's Jason. I would just say, that exactly as we talked about through this call, it's part of, a matrix of a lot of different regulations, whether it be, MiFID, AIFMD, every manager has sort of a specific situation that they may or may not be covered by. But, if you just look at the core, or sort of what's the goal of this type of regulation, right? It's that managers take cybersecurity seriously, that they make sure their investors understand that they sort of have a number of different data rights, and whether, next year there could be a different regulation, right? So whatever skin the regulation comes in, if the manager is adhering to, good principles of maintaining data, protecting it, making sure people are informed about it, talking to their vendors and understanding that that's part of a sort of ecosystem that they all have to comply with, the technicalities of complying will be much easier, as opposed to just, targeting their policy for a specific law, right? And ultimately, the LPs that are considering investing in the funds or maintaining an investment in the fund, when they hire, due diligence professionals like us to evaluate these things, we're not looking just for minimum compliance, right? So you work with a great law firm, they get you up to speed, you're technically complying with all the nuts and bolts of the law. That's minimum compliance is no longer good enough for a lot of LPs, right? So they want to see that a manager is proactive, that they're addressing these issues, that they're on top of it, and that they're going above and beyond that. So that's the kind of takeaway, I would say.
Yeah. And so, folks, we weren't able to get through all of your questions, but on this last slide here, you can see contact details for all three of us. So I would encourage you to reach out. And this, by the way, is one of many webinars that Navitar has put together. We have additional ones on fundraising, on deal sourcing and deal management. I encourage you to check those out as well at www.navitargroup.com. So on behalf of Daniel Silver and Jason Scharfman, this is Nick Donato, and enjoy the rest of your day.